All right, kids, we're back again. And since Fogbo needs a little more material, obviously, we're going to go ahead and we're going to review what's going to be said in court today. Your Honor, I will begin by rightfully asking if this is a constitutionally defined inferior Article 3 Court of Common Law and Record. Folks, this is probably the single most important question that you must ask at any court hearing, criminal especially, because they're not. Okay? A constitutionally defined Article 3 Court of Common Law and Record is not being exercised, folks. Your Honors, since the first day, this is what I'm going to say. Your Honors, since the day I was arrested, this has been a circus. On 6/7 of 19, my former name was called out at my first appearance, and as I stepped to the mic, my first words were, "That is not my name." And as many here can attest, the judge presiding stated, "We called your name and you stood up." This is not a widely recognized logical path to verifying someone's identity, Your Honor. And whereas I may have been this person's name that it is you're charging me with at one time, I have not been that person for over 4 years. Even the courts of Iowa and of the federal government recognize that I am not and have not been this person. Upon reading of the charges and being asked if I understood the charges against me, I stated that I did not understand the nature and the cause of the action against me, and then challenged the jurisdiction of that court. The magistrate continued on like I didn't exist. During this hearing, Aaron McGowan called me a sovereign citizen over 15 times in a 2-minute period, something only the prosecutor, the FBI, the police, and a few corporate news stations like to call me, something I have never, ever claimed to be. Then 5 days later, the state proceeded to have me rearrested in my cell, taken back up to the front of the jail, re-photoed, re-fingerprinted, and recharged me for a felony charge that should have never been charged in the first place according to the statute language itself. My ridiculously high, unjustified $25,000 cash-only bond was then tripled to $75,000 cash only. The following day, I refused to attend my hearing before Magistrate Johnson. After 2 hours, 2 COs then came to my cell, placing me under legal duress to appear or suffer being placed in solitary. I then attended the hearing against my will, where I re-challenged the court's jurisdiction a second time. I again stated that I did not understand the nature and the cause of the court's action against me. I was then asked to make a plea. When I refused to enter one, the court unlawfully entered a plea for me on my behalf, a practice of law from the bench, something that only I or whatever attorney I may have can do. This is not hard to figure out, folks. Listen to what I'm trying to tell you. The only time they can enter a plea for you is if you are unable to, due to mental disorder or the fact that you can't speak or something to that effect. This was never meant to force people to plea, okay? And it was definitely never meant for a judge to be able to do this for you, because essentially only you or your lawyer can do this. So if he's doing it, let me explain. The job of a judge is to be the mediator and between the parties, and is supposed to be the interpreter for the law. This is the man that is supposed to interpret the law, nothing else, nothing more, nothing less. He does not practice the law, okay? He no longer has to. He's in a judge position. He's not practicing anything. He is the law, or at least he thinks he is. Okay, so anyway, my point being is that only you or your lawyer can plead your case, folks. The judge cannot do this for you. It's not done. If they do it, it's unlawful. All right, so anyway, since that hearing, I sat in the jail for over 2 months on a $50,000 cash-only bond, being told in bond hearing after bond hearing that I was a danger to everyone, my community, the victims, that I truly scared people, until you, sir, finally lowered that bond to $5,000. And somehow, between June and now, I just magically stopped being a danger to everyone, and was released. I feel it important to show the court that there has been no flight, no rearrests, and no violation of the terms of my release. I have been calm and reasonable and more respectful and tolerant with this court than anyone who has gone through what I have should be. That's for damn sure. Since my second bond hearing, I have challenged this court's right to subject matter jurisdiction over these parties 4 more times, and it has been ignored, it has been purposefully avoided, and 4 months after it should have been addressed, it's going to be addressed today, and address it we shall, Your Honor. The only reason that this case is still a case is obvious. The victim needs the no contact order against the alleged victim, his counsel, and his family to remain in force, though his family primarily resides in another state entirely and absolutely out of this court's jurisdiction, and though 0 of those parties are claiming to be victimized in this case at all. More so, the alleged victim needs to continue in his crime in installing the 5G network, and keeping me busy or in jail is paramount to accomplishing that end. First, though, this court must finally prove it has jurisdiction over the subject matter of these proceedings. And in order for it to do so, it must first declare for the record what the nature and the cause of this action against me really is. Your Honor, is this a civil or a criminal action? If he should say civil, since this is in fact then a civil action, for the record of the court, I ask that this case be dismissed. There's no affidavit of damage from an injured party, and no injured party is present. Now, if this, he should say, well, the state is the injured party. Thank you, Your Honor, but if that's the case, sir, then we are in the wrong court. This matter needs to be moved to federal court. If the state is the injured party, then it cannot also be the prosecutor and the judge in this matter. That is a blatant conflict of interest, and the case must either be moved to federal court or be dismissed. If he should say this is a statutory or state jurisdiction or any other crazy jurisdiction that they dream up, thank you, Your Honor, but that raises another question. I have not heard of, nor have I read of, any such jurisdiction as it exists under the Constitution of the United States. If there is such a jurisdiction, then I ask this court to please provide me with the published rules of court for this jurisdiction as it appears in the Constitution so that I can intelligently prepare my defense. Now, if you should say that this is a criminal matter, say, thank you, Your Honor. The Constitution of the United States provides this court with 2 jurisdictions under a criminal jurisdiction in which to prove that it has subject matter over the proceedings in a criminal matter. Criminal jurisdiction under the common law and criminal jurisdiction in admiralty or military tribunal venue. Under which direct jurisdiction is this court bringing this action? If he says common law, thank him. Thank you, Your Honor. In the case of a common law jurisdiction, there must be a sworn affidavit of damage from an injured party, and there is no injured party present. Therefore, I motion that the case be dismissed with prejudice. If he should, for very unlikely reasons, say Admiralty Military Tribunal Venue, which is what they are operating under, say, thank you, Your Honor, since you have stated the jurisdiction under Admiralty Military Tribunal Venue, this means that you are declaring me to be operating under some international agreement. If you would be so kind as to produce the contracts or agreements that I have signed that allow me to be tried under this jurisdiction. Folks, the fraud of the court will be brought out today. And you can shut me up, you can put me in contempt, you can put me in jail, I don't care. But I'm going to speak. I'm going to speak, and unless this guy can prove his jurisdiction, then he has to dismiss the case. The case has to be dismissed. And you know, they say, the judge can't dismiss it, the state has to dismiss it. Well, the state's going to have to, because it has nothing. One thing I will guarantee you, by the end of this day, folks, that felony will be dropped. It'll be recharged as a misdemeanor again, because the state statute is very clear. And my advisory council, of which I have, and which nobody else has had in this state for a very long time, has informed me that they're going to drop that part too, because they cannot charge it according to the very law of the statute. Okay? So let them try. They're never going to make it. Thanks a lot, guys. I got to go.